says the owner. That way the owner protects themselves. If it doesn't list anybody, it says no exceptions, everybody's been paid, our money's going to the general, and everybody's paid. Well, I've used this defensively and offensively. The final contractor affidavit is again, it's supposed to be served on the owner within 5 days prior to filing a lawsuit. In other words, I've had cases dismissed because the other side never served the owner with the contractor's affidavit. But what a smart attorney does, we don't do that anymore. we don't move to dismiss these cases anymore. We assert it as a defense, saying, hey, you never served the final contractor's affidavit. Well, I'm going to tell you about a case where I wound up suing a large law firm for malpractice for big money. What happened is my pool contractor client won the case. Up on appeal, the entire case was reversed because the contractor never served a contractor's affidavit prior to filing the lawsuit. Now, we're about to get into the next one. It says, I just want to take a brief sidetrack. You have 1 year to file your lawsuit to foreclose on a lien. Okay? 1 year to file a foreclosure lawsuit to foreclose on your construction lien from the date that it was recorded. So if the lien is recorded on February 1st, you have until February 1st of the following year to file that lawsuit, otherwise your lien is gone. Well, case law says that notwithstanding that you have 5 days prior to filing a lawsuit to serve your final contractor's affidavit, as long as you get it in before that year, that final contractor's affidavit before that year expires, that's okay too. Because they recognize that you could have filed that lawsuit all within that year. Well, anyway, these attorneys, they wound up getting the affirmative defense. It was buried in the affirmative defense number 14 or 21 or whatever it was. And the attorney never, it's a one-page document, and that's all it is. Attorneys never served it on the owner. The entire case was reversed, even though the contractor actually won, and the contractor wound up having to pay the owner their attorney's fees because the lien got thrown out. I wound up suing the attorneys for malpractice and won, and we got all the money back. They weren't happy. So, we just talked as well about 1 year to file a lawsuit to foreclose on your lien. So now you recorded your lien on February 1st. You have an entire year to file a lawsuit. If you don't, it's forever waived, barred. You're never going to get it back. It's gone. So you either file a lawsuit or it's gone. Now, there's a way for an owner to shorten that time frame from 1 year to force you to file a lawsuit on that claim of lien to either 60 days or even 20 days. Now, the one way to reduce your time frame to 60 days is by recording it in the county recorder's office, the same place that you recorded the claim of lien, with something called a notice of contest of lien. It is a very innocuous, inconspicuous letter because it's only one sentence or two sentences, but it is stamped by the clerk. And what it essentially says is your time frame has been reduced to 60 days to enforce your lien rights. And the way you do that is by filing a lawsuit. Now, there is no such thing as a contractor representing, or anybody representing themselves, unless, I guess, they're an individual filing a claim of lien. So an individual can, let's assume that it's the individual who's enforcing their claim of lien, they can represent themselves. Most people operate through companies. The companies have to hire lawyers. There is no such thing as small claims court for construction liens. They have no jurisdiction over liens. So just be aware of that. So like, let's say that your lien is for $5,000 or under. Small claims cases have no jurisdiction over that. Let's assume that you have a $5,000 dispute. That's fine. You can sue them in small claims court, but the court will never give you your lien rights. You'll get a $5,000 money judgment if you win. So whenever I file my cases, there's 3 levels of trial courts: small claims courts, then there's county courts, which are between $5,000 and $15,000, and then there's circuit courts, which are above $15,000. But circuit courts have the jurisdiction to be able to hear lien claims for even $1. I mean, it doesn't matter what it is. They have jurisdiction for any lien claims because it affects real estate. Anything affecting real estate, the biggest courts, I'm always in there only because they get it. The smaller courts not always do because they're not always used to dealing with these issues. So now let's assume that you get a notice of contest of lien on your lien. You now now has only 60 days, and it's going to say 60 days from the date that's indicated in there, not from when you receive it, but it's from when it's indicated in that letter, when it's stamped by the clerk. If you don't file a lawsuit within those 60 days, you may have a problem. Well, you will have a problem. You're not going to be able to enforce your lien. Also, if you're that general contractor or whoever is in direct contract with that owner, and you get the notice of contest of lien, you better make sure that you also got that final contractor's affidavit in there. Because now all your time frames have just gotten shortened. I remember that became an issue in one of my cases. Is it 5 days prior to the 60 days expiring, or do they get the full benefit of the 60 days? I think in that case they actually still have all the way up until that 60th day for the final contractor's affidavit. Now, there's another way. Let's say that the owner really needs that lien off and they want it done fast. They can also file a complaint for an order to show cause as to why your lien should not be discharged of record. What's the difference? Well, one costs $18 at the notice of contest of lien. The other one costs $300 and something, plus obviously they need to pay an attorney to draft it up, so you're talking a lot more money. But if you really need that lien off, you file a complaint for an order to show cause. It's pretty quick. It's pretty short. And what it says is if you don't file a lawsuit against my client, the owner, then you have forever lost your lien rights. Now, on 2 occasions, one, I got a complaint back, they filed the lawsuit, but it came after the 20 days. I said, too late, too bad, so sorry. They lost their lien rights, the lien was gone. Order discharging lien. On the other case, I had the other attorney, they filed everything but a foreclosure. They filed against me for breach of contract, for unjust enrichment. It was a long complaint. I had to look through it 3 times. He said, am I missing something? They didn't even file on the foreclosure of lien. I had the whole thing thrown out. I said, look, I only brought this claim for you to file the foreclosure. They didn't file the foreclosure. I said, it has to be discharged. I said, Judge, you have no more jurisdiction over this case. I said, if they want to file a new lawsuit against us, let them file a whole new lawsuit, but I'm done with this. And so that was granted. And in both of those cases, I actually got attorney's fees against the attorneys. Now, little do they know, not the attorneys, but their clients, had they actually read the statute a little bit closer, they would have realized that technically you're only entitled to to attorney's fees to the prevailing party to enforce a lien. They never enforced the lien. So technically I wasn't entitled to attorney's fees. I got the attorney's fees because they really didn't read the statute very closely. It's generally accepted that whoever prevails wins attorney's fees, but if they actually read it, they would have understood that technically I wasn't entitled to it at all. So, we're going to skip the notice of commencement page and we're going to go to the cartoon because we've already spoken about the notice of commencement.
3 minutes.
And I'll let you read that cartoon. Well, why don't we stop again?
Okay.
Okay.
Start up.
How are we doing on time?
10:20.
Okay.